Aloha, this is Professor Porter. This is the Federal Rules of Evidence, specifically the policy rules, Rules 407 to 411 of the rules, and specifically today, Rule 410, which has to do with pleas and plea negotiations. It's essentially a criminal counterpart to Rule 408, which has to do with settlement negotiations in a civil case. These are plea negotiations in a criminal case. So imagine that someone is charged criminally, and there's times when they too are negotiating a resolution of that case that's in federal court. And there's really a couple different moments when they're negotiated. They might be sitting down with their attorney, talking to the prosecuting attorney or the assistant U.S. attorney in the case who's representing the United States. You can imagine they're negotiating what will be the contours of the plea, what will the person plead to, what maybe could be recommendations or promises to recommend things in sentencing. So there's a negotiation that goes on the same way that it would happen in a civil case to largely settling to an amount of money. There's plea and plea negotiations. There's also, when we have a plea under Rule 11 on the federal side, there's also a time when the defendant under oath raises their hands, put under oath in the court, and is asked essentially what they did. It's a colloquy with the court that where we probe to make sure that they're actually guilty of the offense that they're pleading guilty to that day. You see this in TV and the movies a lot. You see it in Law and Order that there's a time when they're actually someone's actually pleading guilty and having a conversation with the court, and then the court has to essentially accept that guilty plea. Well, I want you to imagine for 410, just the same way 408 covers settlement negotiations that are ultimately do not resolve the case. If the case is settled, it doesn't go to trial. We don't have to worry about federal rules of evidence. We don't have to worry about federal rule of evidence 408. Well, in a criminal context, we don't have to worry about 410 when the majority of cases to which the defendant pleads guilty and offers statements before the court then proceed to sentencing and don't have a trial because they pled guilty. This rule really has to do with failed pleas or plea negotiations that do not result in guilty pleas, and we're still proceeding to trial. So keep in mind, all of these federal rules have to do with governing an eventual trial in this case, and it should be somewhat intuitive, especially in the criminal context, that the idea that someone at one point, a criminal defendant, stands before the court and says, I am willing to plead to count one of the indictment, and then for one reason or another, the court doesn't accept the plea, or the plea is withdrawn, or the court allows the defendant to withdraw their plea for some reason or another. When we proceed to trial in that matter, of course the government would want to say at one point he stood up in open court and said, I plead guilty to count one of the indictment, but you also understand that that probably isn't going to be fair. That probably is going to be covered by Rule 10 and Rule 410, and you'd be right. So here it is, and it really prohibits the use of using sort of not only the guilty plea, sub 1, A sub 1, or a nolo contendere plea, which is essentially a way of saying that you don't contest your guilt in this case. The actual event of the plea cannot be used in a civil or criminal case against you. And you can see. Then you can see the next one. It also has that broad provision that 408 had, that it's also statements made during it. Not only do I plead guilty to the distribution of a controlled substance, some type of drug, but I say, yeah, and I recognize that I was dealing drugs every single week at this different weight and charging this different amount. I'm making statements during the course of my plea. That's what number 3 is about. And number 4 is the one that is the most readily tested, because this has to do again with some of those preliminary discussions. What if it's just the defendant meeting with their attorney, with the prosecuting attorney, talking about the case? Sometimes there's not a clear line between talking about what each side knows about the case or whether they have the case wrong and true plea negotiations, especially if it's pre-indictment or pre-charging in a case. If they just come in to have a conversation and the government says, we're thinking about charging you with this violation. Well, I didn't do this violation, but I can plead guilty to something else. Is that a plea negotiation or is that something else? So they ask conversations before. Notice there's no talk about, as we had in 408 with a talk about a disputed claim at the time, there's no talk about actually needing a viable charge or needing an indictment. So it's more, can the court, as a preliminary determination under 104A, can it make the determination that these are plea and plea negotiations, the conversations between the defendant and likely the defense attorney and the prosecuting attorney in the case. And notice you see some of the exceptions to this. The good purposes for doing this are not that broad. They're actually very specific. There's a little bit of a 106 statements to be fairly considered in the context when other statements. So imagine if parts of those statements were introduced in some proceeding for a reason that was relevant to that proceeding. Well, the other parts of the defendant's statement might have to be considered at the same time. That's essentially what 106 says, and that's what the exceptions B1 says. And the other one is kind of all bets are off as it relates to a criminal proceeding about perjury, because if you're under oath and if you've said something that's a lie, then we're going to be able to get into it because it's the subject of the charge. It's not that we're bringing in the statements made during the course of a plea for some other reason to show that you're guilty. It's that we have a separate and independent prosecution. It's another case for perjury. So you really got to think about it using the language of a plea or statements made during a plea. In this case, that result that was the basis for the charge in the first place and the plea negotiations that failed in the first place.